sir. Friends, we are starting now. Today is 194th Friday group meeting. The topic is constructive liability in criminal law. Speaker is our beloved senior advocate, former judge, Justice Nagamuthu. Earlier, sir addressed in several times. That is a 81st Friday group meeting, 92 Friday group meeting, 93 Friday group meeting, 98th Friday group meeting, 115th Friday group meeting, 142 Friday group meeting, 157 Friday group meeting, 166 Friday group meeting, and 176. Today is the 10th time you are addressing. And moreover, sir, contribution for Friday group in YouTube viewerships 2,20,000. Calculated. The several topics is already all are in a YouTube. Sir, now you can initiate your this time.
Good afternoon, my dear friends. I am extremely happy to stand before you once again to give a short lecture on yet another topic which, according to our organizer, Mr. Rao, is a very important. I thank him for having given me this wonderful opportunity. I also thank all of you for having come over here in large numbers to hear me lecture. Let me go into the topic now straight away without taking much time. Every person who commits an offence is liable for punishment. What is an offence? An offence is an act which is made punishable either under the Indian Penal Code or under any other special or local enactment. If a person has done an act and if that act is an offence under any one of the provisions of Indian Penal Code, for our lecture let us take Indian Penal Code first, then he is liable certainly for that offence. Punishing a person for not an offence that he has not committed is an invasion into his right to life guaranteed under Article 21. Therefore, every person who commits an offence by doing an act, he is liable for that act and ultimately liable for punishment for that act which is an offence. Now, for the act done by A, which is an offence, whether B can be convicted. Yes, in certain circumstances. This liability we call as constructive liability. In essence, though this man has not committed that offence by doing that act, he is also punished while punishing the person who has committed actually the act. This we call as constructive liability. You all know that I am referring to section 34 of the Indian Penal Code. For example, let us take a case of murder. There are two persons who are involved in that. Two persons go together, both of them go near the deceased. One person catches him hold, the other person attacks him and causes his death. Here, who has caused the death? It is only the first person, that is A1. If you look at section 299, which speaks of culpable homicide, it starts with the word whoever causes the death. Now the person who has caused the death is the one who is to be punished for culpable homicide. Here in this case, in the illustration which I gave, admittedly death was caused only by A1, not by A2. Therefore, A1 is to be punished for murder or under section 304 for culpable homicide. But how to punish A2? A2 can be punished constructively for the act done by A1. This is what section 34 plays. Now if you look at section 34, originally as it was enacted, some words were missing. Now section 34 says, acts done by several persons in furtherance of the common intention. This in furtherance of the common intention was not there originally when this act was enacted. After a judgment of the Privy Council, these expressions were included in the year 1870. Now what does it mean? Unless we understand the scope of section 34, there is likelihood of miscarriage of justice in getting some person punished for nothing that he has done which is an offence. Therefore, we should understand the scope and ambit of section 34 first. It is very, very essential. The other provision about which I am going to now refer to is the section 149. There also, for the offence committed by someone, few more persons are also convicted constructively by invoking section 149. These two provisions play a vital role when an offence is committed, when more than one person is involved in the occurrence. Now section 34 speaks of, first thing, common intention. What do we understand by common intention? See, I have an intention, because I have an enemy, I have an intention to cause his death. It is my intention. So long as it remains to be only an intention, I cannot be punished, right? It is only an intention. Thereafter, I also make a preparation for that, to commit that crime. Mere preparation is also not an offence except in certain circumstances, like preparation to commit robbery, dacoity, like that. So mere preparation also would not make out an offence. Intention which leads to preparation, then that preparation should lead to the actual commission of the crime. So what for the man is punished is for the offence that he commits. Ultimately, for that only he is punished. Therefore, in this provision, it speaks of common intention. So I told you about my intention to commit a particular crime. Similarly, yet another person may also have the same intention. The victim may be his enemy also. He may also be thinking of doing away with that man. He has got the same intention. I do not know that he has got the intention like me, my intention. He may not know that also, that I have got that intention to do away with that person. So here there are two intentions. One intention is with me, and he also has got the same intention. He is also preparing to commit that crime. So these two intentions are nothing but similar intentions. Similar. My intention and his intention are similar in nature, because both of us are thinking to do away with a particular person, but without knowing each other's intention. Now at one particular point of time, we meet, and I slowly tell him that I got this intention, this fellow is doing all these harms to me, I want to do away with him. So I express my intention. He says, oh, your intention. I do have the same idea. I do have the same intention. He also expresses. Now, when these similar intentions are exchanged and there is a concert with the results, this concert makes this intention as common intention. So what was an individual intention or a similar intention has now become a common intention between these two. Now, in furtherance of this common intention, that is, because of this intention, on account of this intention, something should be done. Something means the intended act should be done. What is the intended act? To do away with one X, to cause the death of one X. That is the intention. That is the common intention now. Now, both these people go together. On account of the common intention, one person stands outside the house, one trespasses into the house, or both of them enter into the house of the deceased. One doesn't do anything except guarding to see whether anybody is entering, whether anybody is able to see, etc., etc. The other man only causes the death by strangulation. Now, it is no defense for the A2 to say, I did not even touch him, I did not even cause any injury, I did not cause the death, therefore I cannot be held liable for murder or culpable homicide. It is no defense for A2. Why? Whatever was done by A1, that is killing the person, was not out of his individual intention. His individual intention had already become a common intention by pre-meeting of mind. We call it as pre-meeting of mind. So on account of this common intention, he commits the crime of murder, and therefore this person is also constructively liable for that. How is it done? If we look at section 34, it very clearly says that when a criminal act is done by several persons, what is the criminal act here? Causing the death, which is culpable homicide. That act is done by how many people? Two people. But two people, not both of them have caused the death. Only one has caused the death. But this person has also done an act. That is also dealt with in the section. You just see this. When a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. So it speaks of only one act. That act is causing death, culpable homicide. That was done only by one person. The other, he did something. He was watching, or he was catching hold, he was doing something, but he did not cause the death. To understand section 34, you have to go into section 33 of IPC. 33 defines the word act. I said the act of causing death is punishable. That is done by A1. Section 33 defines as to what an act is. It says an act is, act denotes as well as a series of acts. When series of acts are done, all such acts put together make out a single larger act. For that act a person is punished. Here in this case, A1 does an act. What is his act? He strangulates the person. A2, he also does an act. What does he do? He is catching him hold. So both of them have done some acts. A1 has done an act, A2 has done an act. These two acts are done in a series, that is in the same transaction. These two acts make out a larger single act that is punishable under section 304 or 302. Right? Therefore, so far as section 34 is concerned, to invoke that, first thing what we have to see is simply because there are two persons, we cannot rush to say that both the persons are liable to be punished. First thing we have to see is as to whether there was any intention, whether that intention was common. Common intention is denoted by the concert, pre-meeting of mind, whether there would have been any pre-meeting of mind, whether this act was done out of that common intention. Now, section 34 is not a penal provision. Very wonderfully you will see that, very strange. Section 34 is not a penal provision at all. It is only a rule of evidence. It only guides the court or mandates the court as to how to go about. It says, last one phrase is very, very important. Each of such persons is liable for what? For that act, that is murder, in the same manner as if it were done by him alone. This expression is to be given weightage of, and we should understand that. I told you that it is no defense for A2 to escape saying that I have not committed the murder, I have not caused the death. Because by fiction, by a deeming provision in section 34, it is directed that the death was caused by whom now? A1 in reality, as a matter of fact, caused the death. But it is deemed by fiction that A2 also caused the death. This is the rule of evidence. So here, death was caused by whom? In fact, it was caused by A1, in law by A2 also. So each person is therefore liable for punishment under section 302 by invoking section 34. So section 34 is only rule of evidence. Section 34 is not a penal provision. So for section 34, a person to be punished by invoking section 34, there is a deeming fiction that he has committed the murder, though in fact he has not committed. In the illustration, no doubt it is that it was A1 who caused the death, who committed the murder. But by fiction, by deemed clause in section 34, it is held that A2 also caused the death. So therefore, A2 is also liable for punishment under section 302, like A1 who actually caused the death. That is the role which is played by section 34. This is the constructive liability of A2 for the offence, for the act done by A1, section 34. Now, whether section 34 to invoke charge is to be framed in every case. Even in the absence of charge from the evidence, it could be gathered, yes, they have acted in concert on account of or in furtherance of the common intention. Persons can be convicted by invoking section 34. There need not be a specific charge under section 34. Let us not be under the impression that in the absence of a charge under section 34, one cannot be convicted. The reason being that section 34 is only a rule of evidence, it is not a penal provision. Right? Alright, let us go on to the next provision, section 149. Section 149 is also more or less the same, but in my, or as it has been tested in various judgments, it picks up altogether a different concept. Let us not confuse between section 34 and section 149. Section 149 speaks of common object. It does not speak of any common intention. Intention is act specific. It is the intention to go and commit that particular crime. That is the intention. So in order to invoke section 34, the intended act should have been committed. What was the intention? What was the common intention? That intended act should have been committed to invoke section 34, not any other act. Falling outside the scope of common intention, if something is done, section 34 cannot be invoked. Now let us come to section 149. 149, as I pointed out to you, speaks of common object, not common intention. There is some object. What is that object? Object may be many things. What is our object here? Our object here is to learn, to give a lecture and to learn. This is our object. When you are going to a particular place, what is the object? You are going to a shop to purchase. That is the object. Object of visiting a particular place is to purchase something or to attend a meeting like that. So there is object in every human act, there is an object, that is the aim. Now, section 149 speaks of common object. Section 149 speaks of unlawful assembly. So, the term unlawful assembly is defined in section 141. Please, it requires a minimum number of 5 persons. So, when 5 or more persons is required, essential thing to invoke section 149 is 5 or more persons. Now, when 5 or more persons have a common object, there has to be a common object. And when the common object falls under any one of the enumerated offences or acts, then only it becomes unlawful. I am going to tell you about one grey area on which there are 2 judgments of this Honourable Court, with which I got complete disagreement. I am also arguing against it, and occasion may come when the matter is being considered by some other bench. Please kindly look at section 141. This is for your thinking and for making the law correct in future. An assembly of 5 or more persons, so it requires 5%, is designated an unlawful assembly when here there are so many people here, we are in an assembly. Whether this assembly will become unlawful? No. Why? They should fall under this expression. If the common object of the persons composing that assembly is, there has to be something common. That common is some object. That object should fall under any one of these 5 clauses of section 141. Now, first one is to override by criminal force or show of criminal force. Second objective is to resist the execution of any law. Third objective is to commit any mischief or criminal trespass or other offence. Please, here only I am going to concentrate, focus more. Fourth one is by means of criminal force or show of criminal force, etc. Fifth one is by means of criminal force or show of criminal force, etc. to do something else. So therefore, there are 5 categories of objects. 5 categories grouped into 5. If only the common object of the assembly is to do any one or more of these enumerated objects, the assembly becomes unlawful. Now, brothers, the question is, 5 people have an object to go and commit some mischief. 5 people have the object, they want to go and cause mischief, that is by setting fire to the house of somebody. This is the object with which all the 5 go. When they are when they set fire, one person sets fire, the other person is standing like that, they are doing something. Now when fire is set on, what is the offence committed? It is 436 IPC is cast. Who is to be punished under 436? Who actually set fire? One person brought fire, one person brought petrol, one person brought something else, like that one person put it. So all of them have done something. Now ultimately, what was the offence committed? Offence under 436. Who caused? Individually, if you look at, it is not A1 because he only brought petrol. Fire was not set by A2 because he did not do it, because he brought only matchbox. Like that, each one has something to do, but all put together have committed one offence, that is falling under 436, causing mischief of fire. Right? Now, to punish all these persons, we are invoking section 149. How do we do? This is nothing but an assembly. Number 1, there are minimum 5 number of persons. 2, these 5 persons had an object. That object falls under any one of these 5 categories of acts, objects. Therefore, it is an unlawful object, unlawful assembly. When an offence is committed by any one or more members of the unlawful assembly, then everyone is liable to be punished for that offence. This is 149. Now what is the difference between 34 and 149? Please look at section 149 now. If an offence is committed by any member of an unlawful assembly, now here 34 we saw when an act is committed, right? When a criminal act is done, here an offence is committed. So there, the act committed by one person may not be an offence, may not be a complete larger offence. Several acts are done under section 34, several acts. All put together as per section 33 make out a larger single act which is the offence. Section 34. Therefore, section 34 does not speak of offence. It speaks of a criminal act. But section 149 speaks of commission of an offence.
Excuse me, can you?
An offence.
149 is a legal group.
Excuse me, last and end of the question answer.
So 149 speaks of an offence. An offence should have been committed by whom? By any one of the one or more of the members of the assembly. Any one or more of the members of the assembly, an offence should have been committed. So when such an offence is committed, in prosecution of the common object, it is not in furtherance. The language used in section 34 is in furtherance. Here the language used is in prosecution of the common object, that is to achieve the object. However, these 5 people go there to do something which is their object, to achieve the object. If something is done, then every one person is liable for that offence. Now I will tell you how it. See, in the same illustration, 5 people go. What is the object of the assembly? Object of the assembly to set fire, which is an offence, mischief. Now when they are trying to set fire, unexpectedly someone comes and he prevents. He said, don't do that. He blocks the others from doing that. No, if this person is permitted, allowed to prevent, the object cannot be achieved. However, they have already decided to achieve their object. In order to achieve the object, what should be done? This person should be removed. If this person is not removed, the object cannot be achieved. Therefore, one of the persons go and kicks him. Why? To remove him, to remove the obstacle. Then that person unfortunately receives some injury, he dies. Was it the object? No. This person's killing was never the object of the assembly. The object of the assembly was only to set fire. But what was the offence committed now? The offence committed is culpable homicide. Now, can other people in the assembly say, no, I have not done anything. Why? I was only a member in the assembly. No, we never had any object to kill him. Our object was only to set fire. Therefore, don't punish me for this. This was done by that man. You punish him. Don't punish me. Can this be a defense? Section 149 is an answer. No. When this offence was committed, why? By this person, why? To achieve the common object. To achieve the common object, this act was done. But this was never intended, this was never the object. Though the object was one and the resultant offence is different, for this offence all are liable to be punished. This is section 149. Whereas in section 34, the intended act should have been done. The intention was to kill. That should have been done there by doing several acts by the persons who have the common intention. But here in 149, the object is to be achieved. If the object is achieved by all can be punished. There is no difficulty in that. But when an offence which are never the object is committed by one of the persons of the assembly, then all are liable for that offence of culpable homicide. The reason being that the culpable homicide was committed by one of the members not out of his own intention. It was done only to achieve the common object. That means it was also done on behalf of, as per wish of all the people. That is the inference that we make. Therefore, please friends, I want to only highlight this aspect. The basic difference. Intended act should be committed for 34, but for 149, the offence committed need not have been the subject matter of object. It may be totally different, but still it's a very such dangerous position. Still everyone can be punished like the person who committed. Now there is a fiction under 34. A only causes the death, but by fiction, as I told you, B is also deemed to have caused the death there. But here there is no such a deeming clause. It is a penal provision. Section 41 IPC says that whatever is declared as punishable is an offence. Here it is declared by law under section 149 that it is an offence. Maybe that you have not committed, you have not caused this, but this was done. Why? It is because to achieve your object. Therefore, it is not by deeming fiction. It is by declaration of law under section 149. This has been made punishable. So, section 149 is a penal provision, right? So, therefore, necessarily there has to be a charge under section 149 because it is a penal provision. It is one thing to say that by mistake, if there is no charge under 149, whether conviction can be heard under section 149 by invoking section 149, it is a different subject. I do not want to go into that given the time of 45 minutes. I do not want to go into that now. It is a different subject. But for the present, please understand that to invoke section 34, there need not be a charge under section 34 specifically, even in the absence of the same. From out of the evidence, if the court could gather, yes, that there was common intention, then section 34 can be invoked. But so far as section 149 is concerned, my humble view is that there has to be a charge because the purpose of the charge is to indicate, to put on notice to the accused that this is what is there against you and therefore you are answerable to that. Therefore, there has to be a charge under section 149. Now, what is happening now in the system now? My question is, there are 10 people, can they not have a common intention? 10 people, they can have the common intention, they can share the common intention, everyone can participate in the action, something can be done and some offence is committed. Can they not be punished by invoking section 34? But there is a popular misconception that when there are 5 or more accused, it is 149. When there are less number of persons, it is 34. So normally that is how we have been taught also in some circles, let us say that in colleges. When telling us the difference between 34 and 149, it is often said 5 or more persons frame charge on 149, punish him on 149. If there are less number of persons, frame charge on 34 and punish. This, in my humble view, is a wrong approach, is a misconception. I would say that even 10 persons can have.
No, so you have to subject.
Even 10 persons can have common intention. So, though there is no charge under section 34, if from the evidence it could be gathered that only 10 persons had common intention and they have participated in the action, if pre-concert or pre-meeting of mind is also established, they can be convicted by invoking section 34, D hearts section 149. But for 149, minimum we need 5 people or 5 or more people, and there has to be an object. Now I told you that there is some grey area. If you look at these 5 objects, 5 groups of objects, that is criminal force, criminal force, criminal force, everywhere. Now there are 5 people here. They have the object to cause murder, to commit murder. Whether these 5 people can form an unlawful assembly for this matter is a question. In other words, object is to kill a person, to cause the death. Whether this object can make the assembly as unlawful, this is a grey area, because you look at third group of offences in section 141. Third, to commit any mischief. In the illustration I told you about the mischief, we are going to set fire. So when to commit mischief is the object which is common, then the common object, assembly becomes unlawful. Everyone can be punished by invoking section 149. To commit any mischief or criminal trespass. 5 people have the object to go and criminally trespass into the house of someone. And while trespassing, the owner comes and prevents. One person attacks you, he dies. So it is no different to say that our purpose was, our object was only to trespass criminally. We never had the intention or object to kill. Still, for this offence committed, which was never the object, everyone can be punished under section 149. So the first one is mischief, the other one is criminal trespass, the last one or other offence. Other offence. Now what do you mean by this other offence? No, this honorable court in Manga, what is judgment? You please kindly read the judgment. 2013, 7 SCC, page 629. Before that there is no judgment, brothers, and there are judgment. I do not have time today, otherwise I can refer to the judgment of the Supreme Court of Sri Lanka taking one view, Supreme Court of Singapore taking a different view, similar view earlier. Now there is a different view from that court also. In our court there was no judgment until 2013 interpreting this class 3 of section 141, to my knowledge. 6 to 9. First time this was interpreted by the Honorable Supreme Court in this Manga versus State of Uttarakhand. In this case, the Honorable Supreme Court, with great respect, has fallen in error in interpreting this provision. The Honorable Supreme Court says that if the object is to commit any offence, the assembly becomes unlawful. The object is to commit any offence. Where do you get it? They trace this into class 3. Class 3 speaks of to commit any mischief or criminal trespass or other offence. The Supreme Court has interpreted that other offence means to commit any offence. If the object is to commit any offence, the assembly becomes unlawful. Therefore, if the object of the assembly is to commit murder, the assembly is unlawful. If the object of the assembly is to go and cause voluntary hurt, it is unlawful. The assembly is unlawful assembly. Therefore, 149 can be invoked. My humble and respectful dissent is this. Had it been the intention of the legislature to make the object of committing any offence to bring within the ambit of section 141, they need not labor so much to categorize 5 groups, 5 categories of offences. They could have simply said, if the common object of the assembly is to commit an offence, the offence becomes unlawful. They need not elaborate so much to identify certain offences alone and to group them into 5 categories and say that if the object is to commit any one of these 5 categories, then only the assembly becomes unlawful. They need not go taken so much of pains. They could simply say, what? If the object of the assembly is to commit an offence, any offence for that matter, any offence, punishable either under IPC or under any other special law, local law, it is unlawful. They have not done that. They have categorized. Therefore, the argument before this honorable court, and my argument is also this. This word, other offence in class 3rd used to be read by applying the doctrine of adjustum generis, which means the meaning to this word, any offence, used to be gathered from the preceding words. There is a common thread in all these 3. What are they? Mischief, what is it? It is an offence against property. Trespass, what is it? It is an offence against property. Right? Therefore, the term offence used here should be read adjustum generis by drawing the meaning from the words 1 and 2, which are the preceding words, which means what? If any other offence relating to property is also the object of the assembly, then the assembly becomes unlawful. But here, causing voluntary hurt or causing murder is not an offence against property, it is an offence against the human body. Therefore, my humble view is that in order to invoke section 149, the object of the assembly should be specific to any one of the categories enumerated in section 141. Otherwise, you cannot invoke section 149 at all. It is my argument that I am making before a particular bench. I do not know whether I will succeed or not. But this judgment, this judgment was subsequently followed. This was followed in another case, but there was no discussion in that. I was amicus, but I was asked to assist on other legal issues, not on this legal issue. This never came up for consideration. That is again Dunubai's case, judgment of Honorable Justice Talmeshwar. These are the 2 judgments. That judgment has simply followed this. Whereas this judgment, this Manga 2013, elaborately discusses about this section, interpretation of section 141, and says that if the object is to commit any offence, then the offence and the assembly becomes unlawful. This is the finding of this court. I leave it to you, and you just think it over and may decide as to what the correct law is. This is one aspect. Now, let us go to the next aspect. When there is a charge framed under section 149, because the object is well known, but during evidence it comes out that there were no 5 people, can there be still punishment invoked in section 149? Yes, in certain circumstances. Suppose the charge is some 30 people came, other 25 people could not be identified. Therefore, they are not prosecuted. Only 5 could be identified, 5 could be apprehended. Therefore, these 5 are prosecuted. Now, during trial, it comes out that 3 persons are left now, because there is no evidence coming against them. 3 are left. Only 2 persons are there. Whether these 2 can be convicted by invoking section 149, or can they be convicted by invoking section 34 again? Now let me come to 149. I will say that they can be convicted by invoking section 149. Now how it happens? Out of 30 people, someone, the 30th man, the object of 30 people, object is 30 people go. What is the common object? Common object is a criminally trespass. That is the object. While going there, one person comes and prevents. 30th man, he attacks him, he dies. He attacks him, he dies. Now the 30th man, he is not prosecuted. Why? He could not be either apprehended, he could not be identified at all. Someone, he only caused the death. Now can you now say, no, that man, who is that man? Who caused the death? How can I be held responsible? No, it's no defense. Because as per the charge, how many people participated? 30 people. Now, how many are before the court? Only 5. How many are left now? 3 are left out by giving acquittal. There are 2. These 2, can they say, no, we did not do anything, we are only members, we did not do, we went there only to trespass, that fellow has done that. No, if what that man, 30th man did was, in prosecution of the common object, this word, in prosecution, this always you should keep in mind, giving the most required weightage for that. If he has done, let us put it in this way, the man who comes is his enemy and he doesn't do anything. He doesn't prevent these people from trespassing. He comes there, he is just he is a bystander. This one, 30th man goes and attacks him, he dies. Is it on account of this common object? No. The common object could have been achieved. For that, this man was not a hindrance at all. But the 30th man, after his own intention, after his own some enmity, he has done that. In such an event, these 2 people can escape saying that that man did. That act of that person committing the murder has got nothing to do with our common object. This should be de-linked there. The common object and the offense should be de-linked. If these 2 are de-linked, then these 2 can escape saying that we went there only to trespass, for that you punish us, not for murder. They can escape. But when that person committed the murder only to achieve the common object, that is in prosecution of the common object, then these 2 cannot escape, though the 30th man has not been prosecuted before the court. So it is no defense to say that before the court there are 5, 3 are acquitted, only we are 2, therefore you cannot punish me by invoking section 149. It is no defense at all. It all depends upon the facts and circumstances of the case. Suppose in a different case, there are only a definite number of 5 people who participated in the crime. Only 5. That is a definite charge. The charge itself says that you 5 and 5 alone went there with this object and this person committed this crime. In that case, suppose 3 are acquitted for want of evidence. These 2 cannot be convicted by invoking section 149 because the assembly has been reduced to 2 now. It is not an unlawful assembly because unlawful assembly requires 5 people. But in the first illustration where there are 30 people, though 5 alone are prosecuted and 3 are acquitted, there can be a finding by the court, yes, 30 people came. That was an unlawful assembly and these 2 were members. Therefore, these 2 can also be punished by invoking section 149. Now, let us say out of these 5 people, different number of 5 people, that is a charge. You 5 went there, only 5. You come, this was the object. In that, 3 are acquitted. 149 cannot be invoked now. Can you invoke section 34? Can you say that you have framed a charge for object, but you are punishing us for common intention? Can you say that? No. It can be said, it cannot be said also. It depends upon the facts. Now, I have already told you that section 34 does not require a charge because it is only rule of evidence. Now, the prosecution tried to prove that there was a common object and all are to be punished under section 149. Now that story has gone. What remains? From out of the evidence, it is so clear that these 2 people did something. If from the evidence, if the court is able to come to the conclusion, yes, these two people have done it in concert with some common intention. Because section 34 is only a rule of evidence, though in this case there was no charge framed under section 34, these two can be convicted by invoking section 34. In other words, I would say that though the charge is under section 149, and though there is not even an alternative charge by invoking section 34, from out of the evidence it comes out, if it comes out, that these two people had a common intention and they did something which resulted in the offence, then section 34 can be invoked and they can be punished. Right? This is the another difference in respect of charge. Charge 149, punishment under 149, and here punishment under section 34 even in the absence of charge. This difference you may know. Now, when you are defending an accused, who are all prosecuted for offence under section 149, you have to keep in mind first whether the charge under section 149 is correct, whether there is evidence for that. How? Common object. Or if you are defending an accused where he is punished under section 34, what you have to see? Whether there is common intent. First thing. Now, how do you locate it? How do you gather it? Can anyone come and say, yes, we had a meeting yesterday and we had this exchange of ideas and he had that intention, I had that intention, we have shared it, therefore sharing a common intention. Who will come and say? Accused won't come and say. He can at the most say in his confession to the police that is not admissible, court cannot even refer to that. Then how to come to the conclusion that there was a common intention or there was a common object? This is a matter to be gathered from various surrounding circumstances, which means there are several elements into it or several circumstances. Motive is one thing that you have to take into account. Suppose all the people have got the common motive against that person. That is one circumstance that you have to take into account to assess whether there was common intention or common object for the purpose of 34 or 149. Motive. Suppose there was no motive. Then what are the other things? These people came together in a group. That is another circumstance. A1 was having a knife. A2 knew very well, or he was having a pistol, unlicensed gun. A2 knew it. He was bringing the knife, pistol, he was accompanying him. This is yet another strong circumstance to say that they got some meeting, they are coming with some intention, common intention. Right? See, possession of weapon to the knowledge of each other. This is another thing. Then the conduct on this spot. After having come over here, A2 says, don't leave this fellow. A1 shoots. So the deceased is trying to escape. This man says, no, he is trying to escape. Don't leave him. Then A1 shoots. Uttering of these words, that is the conduct of the accused on this spot, also gives an input that there was common intention. Then after the commission of the offence, A1 escapes. A2, who did not do anything because he except accompanying and except doing something there, he goes and verifies whether the man is dead or not. And after verifying, he cries, oh, this fellow is dead. Okay, rush. He goes after that, he rushes. This also shows the common intention between these two. Or else, A2 receives the weapon from A1, keeps it concealing, and he also goes together along with A1. These are all these circumstances from out of you have to gather as to whether there would have been common intention. Similarly, for common object also, from various circumstances, attending circumstances, the court has to gather as to whether there was common object. Then court has to specifically say as to what was the object. Specifically say, because that object which is a finding of the court should fall under any one of the categorized acts in section 141. There has been a clear finding. The one thing to say in how many judgments we find all these things. That is a different thing. Let us not talk about that. So, but it should be there. Intention, what is the intention? There has to be a specific finding. And secondly, there has to be a specific finding that the intended, that is a commonly intended act was done. There should be clear finding on that. In the absence of clear finding on these two, my humble view is that invocation of section 34 is wrong. Similarly for 149, there has to be a finding, yes, there were 5 people, then there was object, yes, that was common, that is known to all. That was agreed upon common object. If this was the object, this object falls under section 141 and this was done in prosecution of the common object, that is to achieve the common object. Unless each one of these ingredients are satisfied, unless there is clear finding on all these, my humble view is invoking section 149 is again wrong. Now, we were talking about the defense. 2 people come. One person is concealing the knife in his hip. This one A2, he is only his friend. He had no enmity with the deceased. He comes with him. And on this spot, now, a quarrel emanates between A1 and the deceased. Now, A1 suddenly takes out the knife and stabs him. The man dies. The culpable homicide. Can you punish A2? Because they were together. They came together. They were together. At the time of occurrence also they were together. And after the commission of the offence also they went together. From out of this, can you gather common intention? No, you cannot gather, because he did not, there was no common motive. The A1 had motive against the deceased, was not known to him. A1 was concealing the knife. He had a plan, he had the intention, he had a plan. He was coming there on seeing this man. He had the definite intention. But this man A2 was an innocent, he did not know. What was there? The intention of A1, he did not know. He was coming. Then on this spot, he did not even expect that man to do this. Suddenly he takes out and stabs. Then after that, after the occurrence, they go together. Why should this man go together? While running away, and he goes in a casual manner, that is how to escape from that place without knowing what to do next. Therefore, in this case, you can clearly say, from these circumstances, you can clearly say, though A1 and A2 came together, there would not have been any common intention. There would have been intention on the part of A1, but it was not shared with A2. Therefore, A2 cannot be convicted under section 34. This you can say. Similarly, for 149 also, from various circumstances, suppose there is a crowd of 5 people, crowd of 10 people standing here, and one person comes innocently, and he comes there to know what is going on there. There is a crowd of people. He comes there so innocently. He also stands in the crowd. Now suddenly some people commit some crime, whether it is unlawful or not. Already there was an unlawful assembly. This man, without knowing what is happening there, he comes and stands. Here technically you can say that though he was in the crowd, he was not a member of this unlawful assembly. He was a member of the assembly, no doubt about that, because he was in the crowd. Assembly means a crowd of people. He came, he joined the crowd. So therefore he is a member of the assembly. Can he be a member of unlawful assembly? No. Because to become a member of the unlawful assembly, there has to be a common object into which he should have knowledge or agreement. That he did not have. Therefore, in that case, we may say that his presence there was so innocent and without any object. Right? This is the way in which we have to distinguish and try to say so what the fact is. Whether, because punishing a person for the offense that he has not committed is a great injustice that we are causing. So a person who commits the offense is liable for punishment for that offense alone. No one can be punished for the offense that he has not committed. For the offense under section, if he has committed offense under 304, you cannot punish him under 302. On account of our ignorance, let this man who is liable for punishment under section 304 should not be punished for offense under section 302. So we should not be ignorant of all these legal provisions. Lastly, I would say, because time is up, I will say only one thing. Whether common intention or common object can come into being on the spot. Yes. Now, though when people assembled there, initially there was no common object. But after assembly, on the spot, there can be a common object formed. This also can be gathered from the conduct of the parties. Similarly, in the case of common intention also, though initially there was no common intention, there was no pre-meeting of mind, there can be a pre-meeting of mind on the spot, at the place, at the spur of the moment. There can be formed a common intention. Two people come innocently to the house of the deceased. What for? They come here to do some compromise. When the compromise talks are going on, now suddenly the one man is not agreeing for the compromise. These two people who were there, suddenly no, this fellow is not agreeing, all right. One man goes and catches him hold, the other man stabs. It is no different to say that we came there only for the purpose of compromise. Never it was our intention, never it was our common intention to commit the murder or to cause his death. Therefore, you cannot invoke section 34. You cannot say that, because though initially there was no common intention, on the spot, common intention was formed, and that was shared. Out of that, this act was done. Therefore, section 34 can be invoked, right? Therefore, in all cases, the common intention need not be a preconcert, means already, sometime before. Preconcert may occur on the spot also. Similarly, section 149 also. I think that this much is enough for the day, because we have gone. So there are so many other things in this, very interesting. There are so many other issues, and the danger today that I am witnessing is that in a very casual manner, section 149 is invoked, people are convicted. The only test superficially seen is how many people? 5, all right, convict them all by invoking section 149. How many people? 2, all right, 34. This attitude should go. This is on account of our ill equipment. I am sorry to say this, because when this law was enacted by Lord Macaulay, it took about 30 years for him to coin these provisions. 34, for such a great personality like Macaulay, was found to be defective later. That is why section 34 was amended after 10 years. So when that was the position of Lord Macaulay, where are we? Thank you so much.
Thank you very much, sir. With a great patience, with a great spirit. Well, 1 second. You are in a hurry. Huh? We give you an opportunity. Thank you. Thank you very much, sir. So nice of you, elaborated with a great spirit, and we are beginning to ending with a great same energy you continue. I request Rahul Agarwal will give please give a vote of thanks, sir.
So on behalf of the entire Retd team, sir, thanks, sir, for choosing such a complex issue, constructive liability in criminal law, and make it so simple, so that everybody of us now has a clarity what's the difference between now section 34 and section 149, and how to come to the common intention that find out with the motives and surrounding circumstances, and you have given a great lecture, and thank you.
Thank you.